Hello everyone, hello friends. This is Heidi Meyers, Immigration and Economic Sanctions Attorney. I thought it would be helpful to do a short video on the Perm labor certification to green card process. So the Perm labor certification to green card is actually three separate applications. The first is the Perm labor certification, which the employer files with the U.S. Department of Labor. The second is the Form I-140 Petition for Immigrant Worker, which is filed with the USCIS, Citizenship and Immigration Services. And the third application is either an application for adjustment to permanent residency if the foreign national is applying within the United States, or it is a consular processing of the immigrant visa if the foreign national wishes to process their green card abroad. So in that scenario, the State Department would do consular processing of the application for an immigrant visa. The foreign national employee would be interviewed abroad and then come to the U.S. with an immigrant visa and enter as a permanent resident. So the first application for Perm labor certification, the employer has to show there is a shortage of U.S. workers who are qualified, ready, willing, and able to do the job for that particular location. So first, the employer has to describe the job with the minimum requirements so as not to exclude U.S. workers. So the employer can't list a whole lot of requirements based on the foreign national employee's resume. So they can't look for the highest qualified individual. They have to describe the job with the minimum requirements to perform the job duties. And the goal is for the employer to look for U.S. workers, to recruit U.S. workers, and they can only get a Perm labor certification if there were no qualified, ready, willing, and able U.S. workers to perform the job. Also, the job offer, the Perm cannot depress the wages and working conditions of U.S. workers. So the first step is for the employer to apply to the U.S. Department of Labor for a prevailing wage determination. Once the employer receives the prevailing wage determination, the employer has to advertise the job. The employer has to run at least a 30-day job order with the local state Department of Labor, and the employer at a minimum has to run 2 Sunday ads in a newspaper of general circulation. If the job offer is for a professional job, the employer also has to undertake 3 additional recruitment steps, such as an employee referral program, a radio advertisement, online advertising with, say, Monster or Indeed, perhaps in a professional journal or a publication. So once the employer has run all these advertisements and the 30-day job order, and there's also a notice of posting at the workplace for at least 10 business days, which is actually 2 weeks. So the employer has to go through all these advertising recruitment measures, and then the employer must interview any U.S. worker who applies for the job and appears that they might be qualified. So the employer has to keep track of all resumes, application letters that the employer receives, and then interview any U.S. worker that appears that they might be qualified for the job. As long as there are job-related reasons for rejecting any U.S. worker who applies for the job, the employer then has to wait at least 30 days after all recruitment steps are taken before filing. So waiting the 30 days after you've done all the advertising and the state job order and the notice of posting, that's to give U.S. workers time to apply for the job. The other aspect is the foreign national beneficiary must not be involved in the recruitment process at all. The foreign national employee cannot review resumes, cannot conduct interviews. The foreign national should be kept totally separate from anything to do with the recruitment process. So, okay, so then the employer files the Perm labor certification with the U.S. Department of Labor and waits for the U.S. Department of Labor to adjudicate it. It generally takes 3 or 4 months for the Department of Labor to review the application, and it might be approved, denied, or audited. If there's an audit, the employer has 30 days to respond. That's 30 calendar days, not work days. Then, of course, the Department of Labor will make a decision as to whether or not to approve the labor certification. If the labor certification is approved, the employer can then file with USCIS, the Citizenship and Immigration Services, the Form I-140, Petition for Immigrant Worker. So the Petition for Immigrant Worker, the employer has to show that it's a bona fide company that actually operates its business and that it has the financial ability to pay at least the prevailing wage or the actual wage, whichever is higher. So with the I-140, the employer has to prove its ability to pay the prevailing wage. So for example, corporate tax returns, employers' quarterly payroll reports, etc., etc. Then the employer also has to show that the foreign national employee is actually qualified for the job and prove their qualifications for the position prior to the time they were hired, generally. So the Perm labor certification is considered a future job, so this is a job offer. Now, if the priority date is current, that means if a visa number is available, the foreign national may also apply for adjustment to permanent residency at the same time that the I-140 is filed. That's called concurrent filing. If there's a backlog in the visa numbers, which is quite common if the foreign national employee is from India or China, or sometimes the categories backlog worldwide, then only the I-140 can be filed and the foreign national has to wait for their priority date to become current to either file the adjustment to permanent residency or to do consular processing. Now, at the adjustment to permanent residency or consular processing stage, the federal government examines whether the foreign national may be inadmissible to the United States, meaning, do they have unlawful presence? Were they here illegally or out of status? Are they subject to the public charge ground of inadmissibility? Do they have any criminal record that might make them inadmissible? Do they have any drunk driving, DUI, DWI history? So at the time of either adjustment or consular processing, all these issues of inadmissibility or perhaps deportability can come up. So anyway, that's a brief overview of the Perm to labor certification process. So the basic points are that it's 3 separate applications. The first, the Perm labor certification, is to the U.S. Department of Labor. You have to show there's a shortage of U.S. workers to do the job. You have to show that the job is being offered at least the prevailing wage or the actual wage, whichever is higher, so that the labor certification will not depress the wages and working conditions of U.S. workers. Second is the I-140, Petition for Immigrant Worker. where the employer shows that they're operating, they're doing business, they have enough money to be able to pay the prevailing wage or the actual wage. They have work for the foreign national, and the foreign national has to prove that they're genuinely qualified to perform the job. And then the third step, as I said, is either the adjustment to permanent residency within the United States or consular processing abroad. And that is the point where if the foreign national has ever been illegally in the United States, ever been out of status, if they have any record of domestic violence, if they have any record of drunk driving, if they have a criminal record, arrests or convictions, all those issues can come up at that point. All right, so I just wanted to do a short overview. Thank you very much for listening. And if you have any ideas for topics later on, let me know. My name is Heidi Meyers. I'm at 11 Broadway, Suite 925, New York, New York, 10004. My phone number is 212-791-4007 or 646-508-5225. And my email is heidimeyerslaw@gmail.com. And don't forget to like this video and subscribe to my channel. Thank you. Bye-bye.